All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here on our case number 1CACV170256, Dallas FISK versus Hurricane AMT LLC. Yeah. As you both know, each side's allotted 20 minutes for your argument. The appellant may reserve time. Keep track of it for yourself. Please give us your name and the name of your client when you approach the podium. We have studied the briefs and the record in the case. We've also discussed the case in our conference. So with that, Mr. Abney, proceed.
It's so much easier to watch one of these than to do it. My name is David Abney. May it please the court. I'm here today with my colleague and friend, Luis Guerra, and represent plaintiff appellant Dallas FISK. I was reading an article last night by Justice Robert Jackson about appellate advocacy, a very nice article from the 1950s. And he says, you know, in a brief, you really should limit the number of issues. And this time I went wild, and I apologize for that. But he said, at the very least, when you do oral argument, please limit the number of issues that you talk about, and which I would definitely like to do that today. I'm not sure if I got them in the order of priority in the written brief, but one of the issues that was troubling me greatly as I was preparing for argument today was the notion that the trial judge allowed questions to be asked about the demand that was made on Holly Cast, and I found that very disturbing, because Rule 408 doesn't allow you to bring in evidence of offers to compromise and compromise discussions and that sort of thing. The trial judge, for whatever reason, said, well, demand is not an offer to compromise, and it's hard to imagine what else it would be.
It looked to me that the demand letter did not come in. Letters did not come in. The only evidence that was admitted over an objection was, did you make a demand? Yes, I made a demand.
Well, there were questions of FISK asked, did you make a demand of Cast or her
Right.
agent or representative? And then Cast was also asked, was a demand made on your agent or representative?
Right. There wasn't evidence of a settlement, though, was there?
No. No.
And the amount of the demand never was.
No.
Okay.
But it occurred to me that this is like if you were working for a newspaper and you gave an article to your editor, and in the article you said, well, Dallas FISK made a demand on Holly Cast, and then you went on with the rest of the story. The editor would kick that back to you and say, how big was the demand? When was it made? What happened to the demand? And was the demand paid? And these are all questions that would certainly come to the minds of the jurors when they hear that a demand has been made on an agent or representative. You hear that word agent, and something clicks in most people's mind, well, an insurance agent or an insurance representative.
But, Mr. Chairman, the jury never asked any questions about that, did they?
No.
So to the extent it may have kicked in their mind, they never thought it was so worthwhile to ask a question or to pursue it further. And wasn't it admitted for a specific purpose?
Well, the purpose was a very odd one. At least the express purpose was that FISK was somehow saying that Cast was not at fault. And there had been an effort to preclude Cast as a non-party at fault, which was ended very quickly by the trial judge. And as my colleague across the aisle pointed out in one of his papers, it was sort of a strange thing to say that you don't want Cast as a non-party at fault. If you're saying on the merits, she shouldn't be a non-party at fault. Because if she's not at fault for the accident, well, then how was the bar at fault for over-serving her with liquor? Okay. But that died right away. And during the trial, Fisk's lawyers made it very clear that Cast was at fault. She had gotten drunk and caused the accident.
Then how is this prejudicial?
Well, it's prejudicial because it raises number one, it violates the rule, and it's prejudicial because it will raise in the minds of the jurors questions and conclusions about what happened. Even if they don't put it into a question, surely some people on the jury were thinking, okay, a demand has been made on agents or representatives.
That there was a settlement.
Yeah,
or that insurance is involved.
That there was a settlement.
So it's not so much that it was used improperly to impeach Mr. Fisk about his contention that all the fault should be here rather than there. it was that it raised the notion that, in the jury's mind, that he's already been paid something.
Well, this is my favorite answer, yes and no. I think certainly that it would raise questions in the minds of the jurors, but also it was also improper impeachment because there really wasn't anything to impeach. By the time you get into the trial, Mr. Fisk's lawyers are saying consistently that she's at fault because she ran the red light and she was intoxicated. And not only she's at fault, of course, the people who overserved her are at fault. So
it's really the notion that he'd been paid something already.
Yes, he's been paid something by her.
Yeah.
The jury wouldn't know how much. Certainly there would be a logical conclusion in the minds of the jurors it was paid by somebody who was an agent or representative, in other words, by insurance. And that's a bad thing.
What's the rationale under 408? I mean, are we talking about, are we encouraging settlement negotiations, or are we worried about placing a thought in the mind of a jury that there might be other compensation? What drives the rule? What's the policy?
This is my second favorite answer, yes and yes. I think it is to encourage candor and forthrightness in settlement discussions because nobody's going to find out at trial whether you were having these discussions or not. And the second part is you don't want the jury to get the impression that somebody has been paid money already in this case, and most likely from an insurance company, and maybe a lot of money, and therefore why do we need to pay any more money? I mean, if he's already gotten a settlement with somebody, the person who was actually ran the red light, why in the world do we have to worry about trying to hold the franchisee or franchisor liable? He's already been paid.
Do you have any authority, any cases that say that's one of the policies is we don't want to lead the jury on to think that there's another pool of money out there that's already coming?
If I didn't cite a case in my brief, I will find one and give you a supplemental citation of legal authority before the roof either falls on me or I'm triumphant.
Probably not under Rule 408, but under just 403 probably.
Right.
Yeah.
That's probably where it would come in. But it seems to me that I've run across cases like that, but I couldn't tell you right now. If they exist, I'll find them, and I will put a citation.
The notion that the jurors may have done this, was there anything else? Was it argued inappropriately by the defendants?
Yes, it was. In closing argument, they specifically discussed the fact that a demand had been made on Cast. So it's sort of nailing the final nail into the coffin on this particular issue, and then the jury goes into the jury room knowing that Cast was a non-party, which is sort of an odd thing for jurors to deal with to begin with. But is she a non-party because she paid plenty of money to settle the case, or maybe her insurance company did? And who knows what effect that would have on the jury deliberations. It's a bad thing.
And there was also an objection when that argument was being made in a closing argument.
I don't think there was an objection at that point, but there had been a whole bunch of objections earlier, and they were overruled. And the judge said, it's fine. In fact, the judge repeatedly said it's fine and allowed it. There comes a point where I think you really don't have to keep objecting if you've made your motions and made your arguments and you've got definitive rulings from the judge.
The court had ruled that the fact of a demand could come in.
Right.
So, yeah.
Right. Well, the fact of the demand and just in plain language, you can ask about the demand, and they asked about the demand and argued about the demand.
I guess I didn't make my point. It wasn't argued inappropriately to what the court had ordered that it could come in for. They weren't arguing to the jury, hey, by the way, they've got an insurance company on board for this.
No, they didn't. They didn't do that. But I would submit that the argument was inappropriate because that whole line should never have happened. This is not the way you handle demands. You don't bring them up. There's no good reason, and the pretext in this case didn't make any sense at all.
See, I always thought, I've not been in your shoes, I always thought that the side that doesn't want insurance to be mentioned is the defense, not the plaintiffs.
You know, that's interesting. No, actually, we don't want it. Almost all my cases are plaintiff for one reason or other. I don't like to represent the defense, frankly, but yes, you don't want the insurance to come in any way, shape, or form.
How is that prejudicial to a plaintiff? Because
the jury gets the impression that somebody has gotten a lot of money already from some source, and they sort of relax and say, well, what the heck? Which means they lower the damages, or they say, well, they've obviously gotten insurance money. What are they doing here, asking for more? The greedy SOBs.
It's the notion.
Yes, Your Honor.
Okay.
It's great to keep it out.
Are you aware of any exceptions to 408?
Yeah, and it's listed in the rule. I don't have the rule right in front of me, but there are exceptions.
Right, and okay, well,
In fact, I usually put these
impeachment is one of them, right?
Yeah, I believe it is. If let me see if I can track that down real fast.
Actually, I've got it here. The court may admit this evidence for another purpose, such as proving a witness's bias or prejudice, negating a contention of undue delay, or providing an effort to obstruct a criminal investigation.
Right, and there was no exception that would fit here that we could ever figure out.
Except that, I mean, now that I understand the argument, I'm wondering whether Rule 408 has any applicability, because 408 would bar the use of it to prove or disprove the validity or amount of a disputed claim. And you're reminding me that really FISK needed to have the jury find cast at fault.
Right, but the fallout of the rule is on several levels. One is it's an inclination that you've already been paid.
Yeah, see,
and there's insurance involved.
Yeah.
And of course the pretext here was that she's at fault, but that doesn't make the slightest sense at all, because the plaintiff had admitted throughout the proceeding in front of the jury that Cass is at fault.
Right. Okay.
It just doesn't fit. And it would cause so many problems, and I believe highly prejudicial problems in this particular case.
Okay.
Another issue, let's see. The franchisee, well, there's the headlight issue. Of course, expert Blyle, I think we briefed this fairly well. The icing on the cake was the police detective who actually physically investigated and examined the wiring and said, well, hold on, Dr. Blau said, and he actually did, Dr. Blau testified, and they say that the running light was definitely on. And then the police lieutenant, she's the one that actually investigates this very carefully and does all the actual tracing of the wires and says, well, hold on, the running light was the one that was not damaged. Blau got the lights backwards. He got the filaments backwards. Instead of headlight, running light, he got them backwards. There's no foundation. He's not a headlight expert. I know he has some experience with headlights and so forth, but if you knock the props out, as far as, well, which one was actually on, and he says this is the one that's on, and it turns out he has the wires backwards. Plus you have two people. You had FISK himself who looked at this. They made a stop at a convenience store. When he got back, he looked at the lights, and they were both on. And then you had the passenger in the oncoming car, in Cass' car, who looks and says the lights are on. So you've got all this evidence directly on point, and then you have Blau getting his wires, literally getting his wires crossed. So I would submit that, I mean, that's hugely damaging. They made that question number one, that FISK was a bad driver because his headlights weren't on and caused the accident or contributed to causing the accident. Huge issue. Their question number one. And I submit that that was wrongly decided by the court, the way it allowed that testimony to go forward. Another issue that I don't know if you call it a pet peeve, because I think it's a huge problem, is rehabilitation of jurors. And there's probably nothing you can do about that, because I think that descends from the heavens upon you and then goes on down to the trial courts. But the notion that you can, suppose we lived in a perfect world, you had an unlimited jury pool. And people who come into you and initially say, I can't stand this kind of person, I don't like drug addicts, I don't like these kinds of cases, I love bars, I don't think you should ever hold a bar liable. And you just, in an ideal world, you get rid of them and you go on with your jury, unlimited jury pool. And I think the rehabilitation thing came about because jury pools are not bottomless. But I submit to the court that to whatever extent you could do anything about that, I would hope that somebody would.
Doesn't the appellant in a case like this, though, have to show that the jury that he wound up with was not fair and impartial?
I know there's a lot. Yeah, you have to show some sort of prejudice, I think, is the way it's usually. And how do you do that? I mean, you really don't know. What you do know is you've used up a couple strikes.
But didn't Hickman specifically reject that as prejudice? State versus Hickman by our Supreme Court.
I think the Arizona appellate courts from the top down have approved rehabilitation of jurors.
No, not on the prejudice. If your allegation of prejudice is I've used my peremptories to remove them, I thought State versus Hickman specifically said that is not prejudice.
I think you're right, and I think they're wrong, but that's about all I can say.
Since we don't have that pay grade, we're probably going to follow Hickman.
Yes, Your Honor. And then the last really big issue, I believe, in my hit parade was the decision by the trial court to say that the franchisor is not liable at all, and then tell the jury that the franchisor is not liable. I'm telling you that you're not liable. There was a wealth of evidence, though, that there was a right to control and some actual control, but definitely a right to control. I tried to, I think I did a good job in the opening brief, but I tried to really focus in on this in the reply brief in pages 12 to 15. I have a list of 25 different things, bullet points or maybe numbers. I thought it was very nice. But it really lays out time after time after time. It's not just that the manuals are very precise and the franchisee is saying I have to follow the manual. But it's testimony from the manager of the franchisee, from the owner of the franchisee, from the president of the franchisor. They're all saying that we have the control over exactly how the alcohol is being served at the franchise. It's very compelling evidence, and I don't know why the trial judge decided that the franchisor would be out. Initially, if the franchisor was staying in the case right along, and then all of a sudden there's a motion for judgment as a matter of law, and the franchisor is gone, and the jury's instructed about that. And speaking of questions, one of the jurors asked about that, and the trial judge said, well, the franchisor is out. Let me make it clear. I believe that was an error, Your Honor, a very severe error.
Is the error taking the issue from the jury? I think I know the answer to the question. Is the error taking the issue from the jury or telling the jury that you have done so?
It's a yes and yes again. And the problem is, part of the problem is, I've been a lawyer a long time, and I still get this franchisor-franchisee thing mixed up in my head. And I could just imagine jurors saying, okay, the franchisor is gone. Why in the world is the franchisee here? You know, if the franchisor is gone, shouldn't the franchisee be gone as well? So, I mean, it's hard to say what the exact ramifications are, but it certainly was not a correct decision under the law and under the facts.
Didn't get that jury question either, though, right?
No. This jury was moderately active, but they didn't ask about everything that one would have liked.
Do you remember whether that was a focus of the closing arguments at all? I can look at that.
I think by then the damage had been done. The franchisor was out of the case.
Okay.
If I may reserve my remaining time. Thank you.
Good afternoon. Your Honors, Counsel, may it please the Court, my name is Timothy Moulton. I'm the attorney who represents Hurricane, both the franchisor and franchisee. Counsel very much limited the issues that he addressed, and of course I was prepared to deal with them all. But I think the most important thing that I would like to talk to the Court about is the standard of review on all of these issues. This, as the Court could tell, I'm sure, from the record and the briefs, this is a case that's been going on for many years. There was substantial discovery, 20 to 30 depositions, a multi-week trial. Judge Warner was very careful in his rulings and put us on a strict time limit. And so here they are in front of you asking you to reverse the case, and it's our position that if you simply focus on the standard of review for all of these issues, their appeal should fail. The way I understand it, the standard of review, for example, of admitting expert testimony. There's a case called State versus, I'm not sure if I'm pronouncing this correctly, Gordeau, 293, Arizona 421. that says those are reviewed by appellate courts under an abuse of discretion. The issue of the juror cause decision, the way I understand it, there has to be a clear showing of abuse of discretion and prejudice, and that's State versus Reasoner, and that's found at 154 Arizona 377. And then all of the evidence rulings, many of which that he didn't argue about, the way I understand the standard of review for this court on those evidence rulings, basically generally such rulings are upheld unless there's a clear abuse of discretion and legal error resulting in prejudice. And so that's why I think the court's questions about, well, how did this prejudice you? How was it dealt in closing argument? And so from our point of view, maybe the most important thing we'd like the court to consider is those three standards of review.
And I know you're going to get to the merits, but I would just like to ask a very specific question. What was the relevance in presenting to the jury the demand?
The relevance was this, Your Honor. I'm primarily a trial lawyer. I don't often argue in appellate courts, but in this case, maybe it's a good thing that I'm here because I was involved in all the depositions. And basically, as I think we mentioned in our brief, when I took the deposition of Dallas FISK, I asked him about the issue of Holly Cast. You know, she's the drunk driver. You admit she's at fault, and he denied it. And he basically said, "Oh no, I used to, work somewhere, and it's all Hurricane. It's all the overservice." And so
I realize that was in your deposition. Did Mr. Fisk testify to that at trial?
No. However, the reason it was relevant and probative, we believe, at trial is an opening statement. And in the last couple of days, I reviewed the entire opening statement of counsel for the plaintiff who's here. And I reviewed the closing arguments. Because through the entire trial, from opening statement all the way to the end of the case, their position was this: Hurricane intoxicated Holly Cast. Hurricane essentially is 100% at fault. And in closing argument, I have a little section of the closing argument and rebuttal I highlighted because at the very end of the case, that's essentially what he argued. And if I may,
did he specifically argue that in his opening statement, or was that you say it was essentially? Because he could make that an issue in the case if he says in his opening statement, Hurricane is 100% responsible, then it would be relevant if that's contrary to what his client said. But what specifically did he argue in his opening statement?
Well, I have the whole opening statement. I can't say he stood there and said Hurricane is 100% responsible, but everything was Hurricane intoxicated her, Hurricane's at fault, Hurricane had all of these manuals, Hurricane is at fault in this case. And then the closing argument, so essentially through the whole case, not one thing about Holly Cast being the drunk driver who got behind the wheel and is at fault or partly at fault because of that.
In other words, it was offered to disprove the contention that she was not at fault.
Exactly. And remember,
that's a prohibited use under Rule 408.
Well, if I may, Your Honor, it's not just that. We designated Holly Cast as a non-party at fault. Also, under the way I understand 122506 sub B, and this isn't discussed much, 122506 sub B about the second or third sentence in says that basically the way I read it in layman's terms is juries shall apportion fault for any party who's settled or any party who is designated by the opponent as a non-party at fault under all of the rules.
Right. But how is that not Rule 408? Evidence of a demand is not admissible to prove or disprove the validity, to impeach by a prior inconsistent statement. So, I mean, it seems to me you were offering the demand to impeach Fisk, saying he was inconsistent before.
If I could, that's a very good question. I understand what your court's saying. And I think the judge a little while ago when asked a question about 408, what's the purpose? Here's our analysis of it. The way I understand Rule 408 is it's clearly designed to prohibit parties at the time of trial or later to say, hey, we had a settlement conference, we had a mediation, they made an offer of settlement, either way, because if you allow that, that discourages open communication and settlement. In this case, it's our position that 408 in the first place doesn't even apply here. This is more of a 401, 402, and 403 issue. Holly Cast was not before this court in the civil case. That claim was not before the court.
Oh, but you've just told us her liability was.
Right, exactly. So I guess what I'm saying is, Your Honor, it's our position that 408 doesn't apply cleanly to this analysis.
Because
the reason we thought it was, and still believe sincerely, that this is admissible, relevant, and probative is at trial, the plaintiff FISK and his attorney were saying Hurricane and only Hurricane is at fault. Holly Cast, I'll show you from the closing argument. I'll read it in a second if I have time. At the end, they said that exact same thing. And in fact, he said specifically, and let me just get to it, page 71 of the closing argument, line 8. Counsel for the plaintiff stood up and said, of all the individuals on this verdict form, and by the way, you don't need to find fault on anybody but Hurricane. You put a 0 right there. The only individuals that have not assumed the responsibility for that portion of this, the collision, is Hurricane. Holly Cass is in jail. She paid for it. She's paying for it. Plaintiff FISK, he'll pay for it for the rest of his life. Again, they're focusing on Hurricane only.
Right.
Holly Cass not being at fault.
So you're saying that the 408 doesn't apply when the party offering the evidence is not the defendant, or is not.
Right, not the parties before the court, basically, is the way I understand it. In addition, Your Honor, it's our position, too, that was their position all along. That was their position from opening to closing. That was their position with all the witnesses. And
Absolutely, we're on board with that.
Yeah.
But I don't think that helps you, because the rule prohibits use of a demand as a prior inconsistent statement.
But it says it can also, it says you can't use it for the things you're talking about, but it says it can be used for other purposes, for impeachment. And the reason we think it's.
But where's the impeachment? I don't see that in the rule.
Well, it doesn't say the word impeachment, but for other purposes. Exactly. For example, credibility. Hernandez versus State is a case that talks about credibility and using it.
But the rule was amended after that.
I understand, but the analysis under 408 and whether other things can be used, and Judge, if I can get to this, we think that making a demand on Holly Cast was an admission of a party opponent under 801. That's an admission that you believe Holly Cast is at fault, or at least partly at fault.
Have you got any cases that apply Rule 408 in this kind of unusual context? Or say that Rule 408 doesn't apply?
Not that I'm aware of, because all the cases seem to be dealing with the classic, parties in litigation. You go to a settlement conference, you make a settlement demand. It's not admissible for that.
So you're saying such as is not a limiting word. So when it's preceded by, it may be admitted for another purpose, such as leaves the door open.
Exactly.
Just examples.
Exactly. Among others, such as. And so although it's not specified, and in this case, Judge Warner was there from opening statement to closing. He was there for this was briefed in motions in limine as well. And basically, Judge Warner decided that, okay, under 401 and 402, I think it's relevant and admissible. And under 403, I'm going to narrow it to all you can say is a demand. And that's specifically what I did. One or two questions of Mr. Fisk, very carefully drawn. And in closing argument, it wasn't question, they say it's question one. They mentioned question one was what we highlighted. That's not really the truth. What we said in opening, and I have my outline for my closing, I said question one is who ran the red light. Question one is who's at fault. So question one was not, if you read the closing argument carefully, the headlight issue. That was just one of, or the 408 issue or any of those things. So question one was, that's not accurate at all. And so getting to the 408 issue, it's our position that 408 doesn't apply, or that it's admissible under one of the exceptions to 408. as an initiative of a party opponent, and under 401, 402, 403, and Hernandez versus State, that it's admissible.
If we conclude it was error, was it prejudicial?
No, Your Honor, we don't believe it was. There were no jury questions about it. There was really no argument. In my closing argument, if you look at it, it's like one sentence, and he said this. That's it. And so no one focused on it. The jury didn't focus on it. It was a 3-week trial. And so in the total sea of evidence and expert witnesses and everything else, it simply wasn't. If you look at the closing argument, the real issue was all about who ran the light, who failed to yield. Was
it not error for the separate reason that I think, as Mr. Abney acknowledged, Mr. Fisk had to buy into the notion that cast was the but-for cause of the accident. He had to have that in order to get hurricane.
That's exactly right. Under the dram shop law, she had to have been the proximate cause of the accident, or there's no liability at all. And so that's our position. I see I only have 7 minutes left, Judge. So unless there's other questions on 408, I'll move on to some other issues that counsel mentioned. The headlight issue, Dr. Blyle's qualifications and credentials are in the record. He's got a PhD in engineering, a master's in engineering. He did it 40 or 50 years. He did lots of these headlight analysis. He did the analysis on the crush. The headlight was closed, was off because it was crushed closed, and he found no hot shock. None of this is novel expert testimony. They actually called as a witness the detective who had little or no experience. This was her first headlight analysis. She pulled information off the internet. And those are jury questions. That's an abuse of discretion, and Dr. Blyle is way more than qualified under 702. It was helpful for the trier of fact. It was an important issue. It wasn't the only issue, but it was an important issue about if someone's going to turn left in front of you at night, are they visible? And there was a negligence per se instruction on that statute. On the juror issue, our position is it's clear. I mean, Judge Warner spent 2 or 3 days doing jury selection. The fact that it's jurors number 102 and 106 tells you this was a very substantial jury selection process. Judge Warner was there. He saw the inflections. He saw the looks on their face. He saw the pauses. And so we think that you should clearly resolve that in favor of no prejudice at all, and they haven't met their burden. The franchisor-franchisee argument. It's mentioned in our brief. There was a general verdict here for the defendant. And there was a general verdict for the defendant for the franchisee. And so all the same elements of dram shop would arguably apply if the franchisor was still in the case. And we cited the case that basically that when that happens, we think that if you don't even look at the case law on franchisor, the jury entered a general verdict of a defense verdict here, and we believe it was primarily because the truth and the facts and the evidence showed that Hollycast entered that intersection just as the light changed, and that Dallas FISK going 24 to 26 miles an hour, turning left in front of them without a headlight, we believe, caused the accident. And so all of the franchisor-franchisee stuff, although it's certainly an interesting academic argument, but if you get to the case law, the judge cited in his minute entry the case out of Idaho, I believe it was. And, you know, we briefed this before trial as well because we did a motion for summary judgment. And as I recall, there was one Arizona case. It discussed franchise liability in a very narrow way. And so we had already briefed it, and the motion for summary judgment was initially denied. But when Judge Warner heard all of the evidence, listened to all the testimony presented by the plaintiff, he applied this case out of Idaho, this Ketterling versus Burger King, and he focused on the manual and is it enough when you're talking about franchisor or franchisee liability to have a general national manual that a franchisor issues. Is that enough? And that case held, and Judge Warner held in this case, that that's not enough. What you need is the franchisor, for lack of a better term, putting their fingers in, actively serving, not serving alcohol to somebody like Holly Cast. And in this case, there was none of that.
Counsel, let me ask you, I'm going to turn your attention to this prior over-serving incident. What was the evidence in the record as to that prior over-serving incident?
There was no evidence in the record. That was at the very end of the trial. We were calling our dram shop expert, Mr. Goodwin, and they had read no prior motions on it, no real presentation. What happens is they just stand up and start cross-examining about something they said was a prior incident of overservice. It's not true. It was a police report that they were trying to hijack the expert with, and it was like a month before, and all it was somebody had a DUI in the parking lot, and they had been at Hurricane. That was it. There was little or no additional information.
Is that police report in the record?
Excuse me?
Is the police report in the record?
No, because what happened is there was a disclosure, as I recall. Maybe there's a, I don't remember it being the record, but what I remember, I just read the transcript. We objected on disclosure, relevance, and
So the questions being asked, you made the
right,
objection.
and the judge 3 times sustained it on disclosure, and hearsay, as I recall, and relevance. And so all that really happened in front of the jury and in front of this witness is they tried to bring this up out of the blue, and he asked, well, what about this over-service? And there's really no proof in the record that there's any kind of, they were there at this time, on this date, this person served them, when they entered, when they left, just nothing. Basically, the only information, as I recall.
Make an offer of proof.
Not that I recall. Not that I recall. So I think there's little or nothing in the record about it, and the judge sustained a disclosure objection and a relevance. And what appeared to me as an old trial lawyer is they were just waiting to the end, and they were hijacking our expert with it. And it's simply, there's, to say it was evidence of overservice or another incident of overservice, there's just nothing there. Your Honors, there are many issues briefed. We think that almost all of them were properly handled. All of them were properly handled by Judge Warner, and almost all of them should be summarily not the basis for reversal on appeal because of the standards of review. This was a long and hard-fought jury trial. Judge Warner was fair and reasonable in his rulings, and for those reasons, we would urge the court to rule in favor of Hurricane and affirm the jury verdict in this case.
Thank you.
Thank you.
As usual, there's a lot to say, and I won't have time to say it. My mind, of course, is fractured at this stage of the process. But under 408, I took a look. I found the rule, and I took a look at it. And this doesn't seem to fit any exception. There is sort of a weird catch-all at the beginning. Usually, the catch-all comes at the end of a phrase, but even I still can't catch what the catch-all would possibly catch here. There's I went back and took a look at the at our briefing just to make sure. But in the opening brief, it's on page 19 of our reply brief. I cite the fact that in the opening argument, Dallas's lawyer told the jury that Lindsay Fisk was killed by an intoxicated guest of the franchisee, and that Cast had caused the fatal collision by running the red light without braking. So you're sort of on a tightrope when you've got a non-party at fault like this. You don't want a whole lot of fault to be assessed to the non-party at fault because that's just nothing. If you say, well, Fisk is 50% at, not Fisk, if Cast is 50% fault here, then that means the most you're going to do as far as the franchisee or franchisor is 50%. So you certainly want to be within the bounds of proper advocacy to put as much blame on the franchisee, franchisor as possible, and as little blame on Cast. But you can't run from the fact that Cast was the essential thing here that caused the death, and all you can do is hope that the jury understands that Cast isn't there, and that you really should be looking at this what started the ball rolling down the hill to cause this terrible collision. The notion that you have to have a jury question to have prejudice, I mean, it would be fun if the jury could do that, but I don't think that really is a requirement. Sometimes the jury questions will give you an insight into something you really don't have an insight into because they're locked in that room, and who knows if they're discussing sports or the case or what's going on. But jury questions can illuminate, but I don't think they're essential for setting up the issue. In the reply brief, pages 12 to 15, I would ask the court to take a look at that, and it's a good list of 25 different types and categories on specific items of evidence about the franchisor. And I didn't mention before, but our expert on proper service of alcohol and by franchisee and the relationships between franchisees and franchisor, he provided testimony on the issue as well. So you had testimony coming from a number of sources, the franchisor's owner, the franchisee president, franchisee manager, and from the expert as well. And they admitted throughout that what you need, and the Idaho case they cite as well, all you need is a right to control. You don't actually have to control, but you do need a right to control, and it's there in spades.
Does the jury's finding in favor of the franchisee render that ruling moot?
You know, I'm not sure, because there may have been jury confusion as to what the relationship is between the two of them, and if one of them is out, maybe the other one's out as well. I don't know exactly the ramifications. It's pretty big, though, when half of the cast leaves the stage, and the jury surely must be wondering exactly why, what happened, and what is the effect on liability. But it would have been nice to have a good question on that, but we came close. There was a question about I think there was a question, is the franchisor out, and the judge clarified, yes, out.
Did the hurricane defendants have two representatives there, one for the franchisor, one for the franchisee?
I don't think so.
Oh, I'm asking the one person in the room who wasn't at trial.
Well, as far as I know, there was just one lawyer representing both, and maybe my colleague, yes.
Okay.
And they didn't need more. He's high-powered, so. I see I've run through my time, but if I may make one more point and tread on your
30 seconds.
toes. Oh, easy. At deposition, we noted that Dr. Block conceded that he had, quote, no, quote, scientific, technical, or other specialized knowledge of the right headlamp from the subject 1994 Pontiac Firebird that was involved on the collision of March 9, 2012, page 9 of our reply brief, and it's cited in other places, and I apologize for taking extra time.
Thank you. Thanks to the lawyers. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.